Hi guys, welcome back to Bar Talk with Ola. My name is Ola Smujola Olua, that's where the Ola is from, and I'm super thrilled to be here once again. Today I want to talk about a very important topic, a topic that is of timeless relevance, to layman law students and lawyers. We want to talk about marriage under the Act, that is marriage under the Marriage Act. So now, in this short series, which will be under, the matrimonial curses playlist, we'll talk about statutory marriage in Nigeria. We'll talk about customary marriage in Nigeria. And customary marriage can be divided or subdivided into marriage under native law and custom and Islamic law marriage. So we'll talk about those two types of marriages under customary marriage. But today we want to talk about statutory marriage, and our guiding ground norm is the Marriage Act. The Marriage Act, Cap M6 in the laws of the Federal Republic of Nigeria, 2004. So you can download it online, it's free, and you can follow it as we talk about marrying under the Act. We're going to be referencing a few sections, and then I'm going to be explaining, how to go about it in Nigeria. Essentially, marrying under the Act in Nigeria is what most people refer to as court wedding in Nigeria. There's no such thing as court wedding. What we have is registry wedding or marriage under the Act, statutory marriage, celebration of a statutory marriage. That's what we have. But you can also, informally call it registry wedding, because it is done and conducted by the registrar of marriage at the marriage registry, not in court. So it is not court wedding. It just so happens that sometimes the marriage registry is also within the court premises. In some instances it is not always the case, and you don't always have to celebrate it within the marriage registry physically. I'll explain that as we go. So that's what we want to talk about today, statutory marriage. In Nigeria, you can only get married statutorily if you are 21 years and above. The exception is that if you are not up to that age, you need parental consent or the consent of your guardian if your parent, is no longer alive. So you must be a bachelor or a spinster, never married, or widowed. And if you are under 21, you have to have a parental consent or the consent of your guardian. But let's follow it from the very beginning. When someone has decided that they want to get married under the Act in Nigeria, the first thing to do is to visit the marriage registry closest to you. You can Google this thing, to check the nearest marriage registry, per your location. So when you visit, you tell them that you want to get married, and then they'll ask you some questions, and then they'll give you a form that is called Form A according to law. Form A is given to you free of charge. You fill Form A and you return it to. According to law, after you have filled Form A, the registrar will enter, it into the notice book, the marriage notice book, and then issue Form C to you, which you will pay for. When you get that Form C, you will fill it, return. It is advisable to visit the marriage registry or to commence this process when you're actually ready to get married, because some of these things are time bound. So after you have filled the form and submitted it back to the registrar will enter it in the marriage notice book and then paste a copy of it on the outer door of his office, or sometimes in practice they paste it on the notice board in the marriage registry. So that will be in existence for 3 months or until the marriage certificate is issued. After that, you'll be given a form that is called Form C to fill. You will pay for Form C. So when you pay, you fill Form C, you also return it to the registrar. Now that Form C will be after 21 days. It will be given to you after 21 days. So ordinarily, after filling Form A and they've entered it in the marriage notice book and then pasted it on the notice board, it is to last for 21 days. It is ordinarily to last for 3 months, but after 21 days you can come back and then you can get Form C and pay. Now the 21 days is given so that, if anyone has an objection to the marriage, they can object to it. So because the marriage registry is a public place, anyone can approach the registry, anyone can be there, can look at it, and then they can object and say, oh, I know this person is already married under the law, don't accept his marriage application, or oh, there's an impediment that will not allow this person and the party they want to marry to be rightfully and lawfully married here. So don't allow that. So that 21 days is allowed for objections and whatnot, and to bring it to the general notice of people, especially people in that locality, that those two parties want to get married. Because also another requirement is that one of the parties seeking to get married must be resident in that locality for a period of time. We're going to get to that, but essentially that's what the notice is. So after 21 days of pasting that notice and entering your indication to get married in the notice book, you will be given what is called Form C, which you will pay for. Now it may vary because things are getting more expensive, or the cost of things are increasing daily. So let's not put a fee to it, but it is quite cheap. Registering marriage in Nigeria is relatively cheap. Let me not say quite, relatively cheap and affordable. So it's not a fee that breaks the bank. And also there are two types of marriage. There's special marriage and there's ordinary marriage. If you check the Federal Marriage Registry websites, you will find those two types of marriage. Ordinary marriage is people who are getting married, Nigerian trying to get married and to live in Nigeria. But special marriage means that a Nigerian marrying a non-Nigerian who is probably outside of the country and is going to come in and get married, or a Nigerian or a non-Nigerian and a non-Nigerian getting married in Nigeria. So the fees vary, for Form C, the fees vary, but those are the two types of marriages that are also recognized by law in Nigeria. So whichever one applies to you, you pay for it. And then when you take the Form C, you will then swear an affidavit of bachelorhood or spinsterhood. The affidavit is to state that there's no impediments. That is, you're a bachelor, you are not lawfully married to another party that is different from the person you now seek to get married to under the Act. Because we've talked about affidavits on this channel. We've also talked about perjury. So you must deposit that affidavit in utmost good faith, and it must be the truth. So if you lie and it turns out that you were lawfully married, to another party, if it's found out, that is perjury. You have perjured. So you have lied on oath, essentially. So that means that you will be liable to prosecution. You are culpable of perjury and liable to prosecution. So it's a crime to lie. It's a crime, an actual crime. And these are some of the foundations of bigamy, which is another offense that relates to marriage that you can't be prosecuted for. So you mustn't lie in the affidavit of bachelorhood or spinsterhood. And this is very important so that you do not defeat the purpose of the marriage registry. You know that the law is that the court does nothing in vain. That's the maxim, rather. So the court, which is by extension the marriage registry, also does nothing in vain. So if they have married you to another person before and you are coming to marry another person in that same registry, you are essentially frustrating the sacredness and the integrity of the process. So that is why you have to depose to that affidavit. So if you go to a registry and you need to depose to that, you might have to pay for it, just like you pay to depose to any affidavit. It's usually a small sum, so it's nothing expensive, very, very minute, very relatively minute, negligible amount you paid for the affidavit. Both parties have to swear it. So the husband under Nigerian law will swear affidavit of bachelorhood, and the wife to be under Nigerian law, the husband to be, the wife to be will swear the affidavit of spinsterhood, and attach it to their application. Now, like I earlier mentioned, one of the parties must be resident in that district within which they want to get married for at least 15 days, to the celebration of that marriage. So usually if parties are coming from outside the country, maybe Nigerians that have moved abroad and they want to get married, it is important for one of the parties to come in and at least reside in that locality for 15 days to fulfill, the law. So it's very important. It's also something that the registrars will question you about. So one of the parties is, if either parties are available, fine, but one of them has to be resident. And of course, if one party is not available, the resident party will be the one, conducting all these processes. Once you have the documents and all the requirements, you can actually file all these processes and, conduct them largely. So it's important that one of the parties is resident in the district where the marriage is going to be celebrated, where the marriage registry is, that particular marriage registry, for at least 15 days. For the purpose of marriage, registries are divided district by district in Nigeria, not necessarily according to some geopolitical distributions, but according to the order of the minister and the law. Their marriages are divided into districts, so you find out what district is closest to you, where you're resident, and then you can approach them and commence the marriage process there. So what's contained in the affidavit? Remember that an affidavit is a deposition of facts. You depose to the following facts: that you have not been married legally before to another party different, from that party that you're about to marry. Because of course, if you're trying to marry the same party, then there's no need for you to go through this process. So essentially, you're telling the court that you're not married, you're a spinster in the real sense of it, or you're a bachelor in the real sense of it. And there's an exemption for widows and widowers. And the exemption is premised on the fact that if you're a widow or widower, then you've been lawfully married before you have complied with the process ordinarily before. So you depose to that. You also depose to the fact that you have been resident within that district for at least 15 days. You also depose to the fact that you're of 21 years and above in age, that is, you are by age lawfully able to get married. And if you are not lawfully able to get married, you have to attach parental consent or the consent of your guardian. You also have to depose to the fact that there's no impediment, no lawful impediment that you know of that can hinder the legality of that marriage. Essentially, impediments could be, you're saying that you are not within the prohibited degrees of affinity or consanguinity. We've talked about that in the video where we talked about validity of marriages. Please check the description box under this video so that you can watch that. So this is supposed to be a precursor to that video, but we are doing it after, so you can watch that video much later, where we talked about prohibited degrees of affinity or consanguinity, that is the limits to which you can marry people that are related to you by blood, birth, or marriage. So very important. You are deposing in the affidavit to say that this person is not within, that circle of people that you cannot get married to who are related to you. Also, that there's no other lawful impediment that you know of that can prevent the marriage or that can affect the legality of the marriage. Also, you depose the affidavit to say that you have not been married to another person or party under customary law. Very important. Now, here's the question, which I think I addressed when we talked about double-decker marriages. That's another video on marriages. You see that this channel is very committed to marriages, so watch that. And so we talked about being married under customary law and then celebrating a statutory wedding, so or a registry wedding rather, is statutory marriage. So it's important also in the affidavit you would state that you are not married under native law and custom to another person other than this party that you're marrying. So for people who want to do double-decker or tri-decker, whatever, who probably have done customary marriage and then want to do statutory marriage. Most people now these days do the statutory marriage. They celebrate it during the weekday and then they do the traditional, the customary marriage, wedding celebrations in the weekend. But if you're not marrying a different person, you can do it at any time. The statutory marriage just takes precedence. But if you want to do, go the whole 9 yards, you can go and do it. But in the affidavit, what you are saying to the court is that you are not married to another person different from this person that you want to get married to under customary law or under native law and custom. And you have to say this to the court. You have to swear to this, because customary law is recognized in Nigeria. It is a lawful marriage, a complete marriage on its own. So if you're already married to someone else, you cannot come and say that you want to get married under the act to another person, a different party, because that marriage is subsisting. So by law, the affidavit is to be deposed to before the registrar or before an admin officer or before a recognized minister of religion. But most people just do it in court. So if you're celebrating your marriage also in a licensed place of worship, that means you will depose to the affidavit before a recognized minister of religion. Also, the prohibited degrees of affinity and consanguinity must be explained to the parties deposing to the affidavit. Very important. It is a requirement of law. As a matter of fact, if the registrar fails or omits to explain what it means and the implications to the parties, and they go ahead and it is found out that they were not told or they were not explained to, the registrar is liable to 2 years imprisonment. So you find that it's very important. They must explain to you the limits by blood, birth, or marriage of persons you can marry or cannot marry. And you will now sign that you understand, that you were explained to, and that you understood. You have to sign. Very important. Remember I said that when you first go and you fill Form A, the registrar will enter it in the marriage notice book, and it will exist for 3 months. But you will be issued the Form C after 21 days. Now, the essence of those 3 months are that if your marriage is not celebrated within the 3 months from the first date when you filled Form A and it was entered in the notice book, that process becomes invalid and you have to start all over. So that's why I said that you should go to the registry and start the process when you are actually ready to get married. Else, you have to start all over, because 3 months is the validity period once you start by Form A. So if after 3 months the marriage has not been celebrated, it will be void. The notices will be void and you have to start all over. The essence of the notice is that anyone who discovers that a party is about to get married and has a caveat as to why, caveat is a Latin word that means beware. So you often see caveat emptor, caveat venditor or venditor, which means buyer beware, seller beware. So entering a caveat is saying beware. There's an impediment, there's an irregularity, don't continue with this process. So if anyone has an objection to the marriage during the notice period, they will approach the registry and they would enter a caveat. So they can enter the caveat by writing the word forbidden, against the notice of the marriage. And also in the marriage notice book, they have to indicate their name, their address, and why, the grounds upon which they are objecting to the marriage. So this is not a frivolous affair, because this will be taken before a judge who will then decide if the reasons or the grounds that they've given is sufficient to cancel the entire marriage process, or it is not sufficient. And if it is not sufficient, if it's found to be frivolous, there's a penalty against the objector. But if it's found to be right, then the process will be cancelled. And this decision by the judge is not done in the absence of the parties. The court will hear all parties. So the court will invite the parties that are about to get married and then determine on the strength of, what is entered in the marriage notice book and the reasons given and evidence supplied by the objector. The court will decide if it is sufficient or not. And that decision is subject to appeal. So it is brought before a high court judge, because marriages in Nigeria all things that concern statutory marriage in Nigeria go before the High Court. So if the parties are not satisfied with the decision, they can appeal it to the appeal court. Also, if the judge finds out that the forbidding or the caveat was entered unjustifiably, it can award compensation to the injured party. Now, if it finds out that the objection is insufficient, it will cancel it and write cancelled by order of court against, that forbidding in the notice book. It will write it cancelled by order of court, and that settles the matter for all intent and purpose of the caveat. So once he writes cancelled by order of court and he signs his name against it, that caveat is invalidated, and the period within which they are to come before the judge and sort out the caveat will not be counted in the 3 months that the notice period is supposed to lapse. So that period will be deducted, and the normal 3 months will be counted for the party seeking to get married. Where a party cannot get parental consent, the governor may consent, the judge of a high court may consent, an officer above the grade of an assistant secretary in civil service may consent instead. Now let's go to the physical celebration of the marriage. Now that all the processes have been sorted, the marriage must be celebrated in the marriage registry or in a licensed place of worship. So sometimes lex loci celebrationis, the requirements of this affects the validity of a marriage. So it could make a marriage voidable. That is, at the instance of a party, the marriage can be annulled. So what do we mean by lex loci celebrationis? That's the place of the celebration of the marriage, and this covers what the Marriage Act has said about where a marriage can be celebrated. So any party cannot just wake up. I know that in some countries you could even get a minister online to celebrate them, or anywhere to celebrate the marriage for you. People get licensed online as minister of marriages, and they can celebrate the marriages. In Nigeria, the marriage must be celebrated in the marriage registry or in a licensed place of worship or at another venue licensed by the minister for the celebration of the marriage. So 3 places. People usually think it's 2 places. Sometimes people think it's 2 places. I've encountered someone who thought it couldn't be celebrated outside, but it can be celebrated in a 3rd place. And I've been at such a wedding. I remember the first wedding I attended post-COVID was celebrated at an events place, and the marriage registrar came all the way to celebrate the marriage. So let's take it one by one. If you're doing it at the marriage registry, very easy and simple. The registrar of marriages will conduct the ceremony. I've been at such a wedding also. So from start to finish, the registrar of marriage is in charge. And that registrar of marriage will be the one that will pronounce you man and wife. If you're doing it at a licensed place of worship, it must be celebrated, according to the rites of that place of worship. So if you're doing it in a Catholic church, they by law have to celebrate it the way that they would normally do a marriage celebration. If you're doing it at a Baptist church, at a Christ Apostolic Church, at a Redeemed Church, wherever, it must be done according to the rites of that church. That is how they would normally do it. And the person that will pronounce you man and wife is the ordained minister of that particular licensed place of worship. So they can put other ministers on the program for any other thing, preaching, thanksgiving, offerings, whatnot, but the minister, ordained minister of that licensed place of worship, must be the one that would pronounce man and wife. Very important. Usually when I attend weddings in churches, I look out for these requirements for validity, because some of these things make a marriage voidable, even if not void. So but if you want to do it at a different place from these 2 places, you can apply, and if you're permitted, you will be licensed to celebrate the marriage at a place other than a church or the marriage registry, and then the registrar of marriage will come to that place to join the couple to conduct the marriage. by license. Of course, you have to pay some extra fees. For instance, if you're doing it, you probably have to pay for the logistics of the court staff that will come, including the registrar of marriages, and then you have to just make sure that they are well sorted and taken care of that. So these are the 3 places where you can celebrate your marriage. Also, the marriage must be celebrated within the hours of 8 a.m. and 6 p.m. with open doors and in the presence of 2 witnesses aside the minister that is conducting the marriage, or the marriage registrar that's conducting the marriage. If it's at the registry, it is done between the hours of 10 a.m. and 4 p.m. 10 a.m. and 4 p.m. If you're doing it in a licensed place of worship, it is done between 8 a.m. and 6 p.m. It must be open doors. That is, the venue must be freely accessible. Not that you would invite the whole world, but it must be freely accessible, and there must be at least 2 witnesses who would also sign the marriage certificate. Very important. So if parties have not submitted all the forms that they're supposed to submit, and the registrar's certificate, because after Form C, the registrar will issue a certificate which gives the go-ahead for the marriage to be celebrated. If parties have not returned those forms, the marriage cannot be lawfully celebrated. Also, if the minister of marriage or the licensed minister of marriage or the registrar knows of any impediment, aside from what parties have deposed or disclosed, to the legality of the marriage, they must not conduct the marriage. They are bound by law. So you see that it's a sacred affair. So both parties, all parties indeed, must be honest, and they must guard. There's a responsibility for all parties concerned and the society at large to guard the sacredness of the institution of marriage. When the marriage has been thus celebrated, the parties, that's the husband and the wife, as pronounced by the minister or the registrar, will now sign what is known as Form E. That is the marriage certificate. Remember, we're coming from Form A, Form C, and then Form D. Form D is the license that the minister grants for the marriage to be celebrated, because all the requirements have been complied with. And then now Form E is the marriage certificate. So it's filled in duplicates. The parties will fill one under their own hand, and then the minister that celebrated the marriage or the registrar will fill the duplicates, and then parties will sign both. There are 2 witnesses will sign both. People use their father, mother, their best lady, best man, whatnot. But the requirement of law is 2 witnesses. So they would sign. They would usually have to put their name, their occupation, and their address, and of course their connection. I believe their connection to the parties. Yes, whether they're father, uncle, auntie, whatsoever. So those 2 witnesses will sign, and the minister that celebrated the marriage or the registrar will also sign. So 2 duplicates, and then the minister or the registrar will enter some details of the certificate that's been filled in a counterfoil. Duplicates are important because I've been asked before, not often, I've been asked before, and even more recently, probably more than once, yes, at least twice in my law practice journey, I've been asked about a party that sought to get a dissolution of marriage, to file for dissolution of marriage rather, and then they could not access their marriage certificates, and they were worried. In one instance, or in both instances, I think what they told me was that the other party was not willing to release it, or maybe one person lost it, the other person, the party they were married to, was not ready to release it. So this is the essence of signing marriage certificates in duplicates. One of those duplicates will be sent to the registry if it was celebrated in a licensed place of worship, or if it was celebrated in the registrar will just take one and file it, and that is the one that constitutes the registry's record. So if in future the copy that was given to the parties is lost, or one party says, I won't give you to do anything, it may not even be for dissolution, maybe one party wants to travel and they need proof of marriage or whatnot, and another party saying, I won't give you. If it was stolen, if it was lost, or if it was destroyed in a fire, in a flood, whatsoever, you can apply to the registrar of marriage in writing for a certified true copy of the duplicates that they have, that they filed when you got married. You see the essence of records. So you apply simple, just write a letter applying for a certified true copy of the marriage certificate and undertaking to pay all accruing fees for that purpose. And then you have a copy of your marriage certificate. If you check section 30, it speaks about this, about obtaining certified true copies of a marriage certificate and conducting a search to ascertain, the validity or existence of a marriage in Nigeria. Also, if you check section 29 is the section that talks about getting a license, to celebrate the marriage in a place other than the licensed place of worship. So what we have talked about in this video is essentially how to get married under the act in Nigeria, the actual celebration of marriage, how to do it. And it's very important to comply with these requirements of law, because not complying with some of them makes the marriage void, and not complying with some others makes the marriage voidable. Voidable means that at the insistence of a party, the marriage can be annulled or it can be cancelled. So that's what we want to talk about in this video. We've talked about section 7 to 30 of the Marriage Act, cap M6, laws of the Federal Republic of Nigeria in this video. You can cross-check for yourselves and you can continue the conversation in the comment section. I will see you in the next video where hopefully we'll talk about customary marriages. Toodles!